presentation on climate change litigation. I'm Rick Pelt-Steele, Chancellor Professor at the UMass Law School in the United States. So environmental litigation has been around for a long time. In fact, you could say it's a kind of property litigation dating even to the 12th century in the Anglo-American tradition, but certainly in the modern era since we've had environmental regulation. What's unprecedented today is the scale of litigation. We see more of it, and we see it all over the world. And what remains to be seen is how effective it will be, whether it will actually bring about social and policy changes, and whether it will have any impact on climate change. So we're going to start with a website, the Climate Change Laws of the World, which you can go to if you like. And we're going to go very specifically to a piece of that website, which is the Climate Change Litigation Databases maintained by the Center for Climate Change at Columbia University. You can see it's broken down into US and global climate change litigation. It's a pretty remarkable data set. It's been analyzed by the Grantham Institute at the London School of Economics by researchers named Setzer and Higham, who produced an annual report on the database contents. And I'm going to share with you some of the data that comes from their report. So the database can be broken into a geographic map in this way to show the number of cases and where they're coming from. We've got most cases, well, we've got 2,341 cases overall, pardon me, and they're coming from 51 countries, also from 50 transnational or multinational or international organizations. 1,590 of the cases are coming from the United States, so that is a majority of the cases in the database. After that, 130 from Australia, 102 from the UK, 67 from the in the European Court of Justice. Now, there's a reason why the US is highly represented here. Part of it is just data collection. So where we see data not coming from some parts of the world, especially Africa, that might be because of poor data collection. It doesn't mean the cases don't exist. Also, there are a lot of cases in the United States. So the US tends heavily to rely on litigation as a civil dispute resolution mechanism. And also, it's a developed country with a relatively weak economic regulatory system. So that causes more disputes to be cast into litigation. So in some sense, the high representation of cases is justified. We see only one case in Russia. That was a case brought in Russian courts to challenge the country's compliance with the 2015 Paris Agreement. The case is no longer going on. It was unsuccessful, as one might imagine. And I point out Russia because you can imagine as well that the low representation of a jurisdiction in the database might in fact represent a low number of cases, but it does not necessarily represent that all is well with the environment in that jurisdiction. We see more jurisdictions represented in the database than ever before, partly because of increase in reporting, but also because of increase in actual cases. So recent new entrants are from Thailand, Finland, Bulgaria, Romania, and Turkey. In 2022, there were 43 jurisdictions. In 2023, the 51 jurisdictions. So there are more cases coming from more places. Another trend we see is an increase in the global south, again, also partly because of better reporting, but also because of more cases. The 135 in 2023 is up from previous numbers with 50 new cases filed since 2020. So if we look at some related data from the chart, this is the cases filed over time, and you can see that they're generally on the rise, especially if you look at that non-United States, those blue bar data representing non-US cases. You'll see that 2023 is unusually low. That's because of the time that of the data capture here. The 2023 data was only halfway complete at the time, so that's not accurate. But you will see that there was a dip in 2022. It's not so much a dip overall, but what you're seeing there is a spike in the years prior to 2022. And researchers think that's attributable to two things. One is the pandemic. And what happened during the pandemic was that you had a lot of NGOs go to remote work. They weren't spending resources out in the world, and so their remote work might have consisted of a surge in litigation. Another factor going on there is the Trump administration's withdrawal of the United States from the Paris Agreement. And that was an impact not only in the United States, but signaled to other regimes around the world that maybe they didn't need to take their agreement obligations seriously. And that is believed to have caused an uptick in litigation. So another way of organizing the cases in the database is by looking at the legal theories that the cases represent. And one large area, of course, is administrative law. And this is especially so in the modern era, dating to the surge in environmental regulation we saw around the world in the 1960s, 1970s. Here are three key developments: the founding of the EPA, international agreements, and European agreements, all dating to that time period. Another large area of activity in litigation is consumer protection. So this happens in both public and private enforcement, especially since the 20th century. You can think about theories of product liability, warranty. In American terms, those are torts and contracts. Theories such as misrepresentation, erroneous advertising. There's especially here an effort to draw parallels in litigation between extractive industries and other defendants who've been on the wrong end of consumer protection litigation, namely makers of tobacco and fentanyl in recent decades. There's also an increase in consumer protection litigation around so-called greenwashing or climate washing. And this is where defendants are accused of misrepresentation about their statements as to the friendliness of their activities or their policies to the environment. So theories here can be fraud, unfair competition, deceptive marketing. Sometimes the industry respondents are caught in compliance battles over their own rules. So industry-wide regulations around product labeling, for example, what is organic, what is not genetically modified, results in litigation here. Another category, tort or delict, kind of classic compensation claims. Here, product liability overlaps with consumer protection, also actions in negligence, in nuisance. There's a lot of activity in the United States over public nuisance, especially against fossil fuel entities, and a lot of debate over whether that's an appropriate vehicle for redress. And then a very active category where we see a definite and recent spike in activity is constitutional law and human rights law. No doubt part of this is motivated by increased litigation under the EU Charter. A lot of it is about getting jurisdictions, or trying to get jurisdictions to comply with Paris Agreement obligations. International judicial entities have been brought in on the action here. The International Court of Justice has been asked for opinions on state climate obligations. The EU Court of Justice has seen a lot of claims over over the EU Charter. And you might have heard of the small island states bringing a claim to the International Tribunal on the Law of the Sea. But older human rights instruments also are getting in on the action. The West African ECOWAS Court of Justice invoked the African Charter in a 2012 case over the Niger Delta. There is a right to a healthy environment in the Inter-American system, and the Inter-American Court is increasingly asked to deliver advisory opinions to promote that right. There have been national domestic courts increasingly active. We see this in South America and Bolivia, Colombia, and Ecuador, especially around emerging human rights and related theories such as indigenous rights and the rights of nature. I want to show you an older instrument that I think is interesting from my home jurisdiction. The Massachusetts Constitution actually added this provision in 1972. And if I highlight some of the language here, you'll see that this really could be construed to be a right to a healthy environment. It was 50 years after this, in 2022, that the Council of Europe asked all member states to adopt and enforce a right to a healthy environment in their domestic legal regimes. Now, this Massachusetts provision has never actually been used for a broad right to a healthy environment. It has only been used to halt development of public parkland, very narrow usage. But it's interesting to me that instruments like this are out there in domestic legal systems around the world, some of them dating from the 60s and 70s, and they're sort of ripe for for domestic courts to pick them up and use them should they choose to do so. So we talk about these legal theories. Another way of organizing our database of case law is to consider who are the plaintiffs, who are the defendants, who are the petitioners, who are the respondents in these cases. If we look at cases that way, we see about 50-50 split between government and corporate defendants, though increasingly that is going to more private respondents and fewer governmental respondents, probably because governments are getting on board with their environmental obligations. Private actors are more reluctant to do so. When we look at the breakdown of petitioners, NGOs are huge in the petitioner action in non-US cases. They're a little less so in the United States, where governments are more active as petitioners. If we look at the kinds of private sector respondents, you see some interesting data. And I encourage you to look at this chart offline a bit and explore the categories. But the large pink or salmon parts of the bars represent fossil fuel. So not terribly surprising there. Very closely related, the dark blue bars represent energy. Although one thing you see as we go from left to right is the increase in the number of sectors that are represented. So what we see here is a broader diversity of the kinds of claims and the kind of respondents in those claims that are happening in the database. And so we see new entrants in terms of sectors on the defense side: chemicals, plastics, construction, retail. A lot of this is driven by greenwashing litigation, but not all of it. Some of it's just creativity on the part of plaintiffs and reaching farther down the supply chain for accountability. So another way of organizing our litigation database is to think in terms of what are the strategies by which the petitioners or plaintiffs are trying to get accountability from the respondents. And this is a way in which Setzer and Hingham organize the data. So one set of cases is so-called government framework cases. This is litigation about the adequacy and implementation of environmental regulations. That is trending upward. We have corporate framework litigation, which is about getting private actors to abate high impact activities, also trending up. There is integrating climate considerations case law. This is about compliance in the development of policies and projects. Here we see a large uptick in action against governments and significant action against corporations that's holding steady. There's also an increase in litigation against private-public partnerships, probably just because that's becoming increasingly a model for development policy and projects. A new category the researchers created is called turning off the taps, and they sort of distilled this from prior existing categories because there's an increase in litigation against both public and private defendants in an effort to attack financing of environmentally impactful activity. Another category is failure to adapt. So this is litigation that urges the respondent to consider climate risks or goes after the respondent for failure to transition to environmentally friendlier activity, such as low carbon activity. And here we see an increase in activity and litigation against governments, about the same, holding steady against private respondents. Polluter pays is kind of more tort-like litigation in the classic pay for the impact of your activities compensation type litigation. This is increasing against government, holding steady against corporations. There is the climate washing or greenwashing litigation. And as I mentioned, this is going up. It's going up against government. It is going way up against private actors. So an increase year over year from 13 to 52 cases from 2022 to 2023. In terms of personal responsibility, these are cases against individual actors. So they might be politicians or officials. They might be actors on behalf of corporations, such as executives brought by shareholders or by pension beneficiaries. And these litigations are rising. And finally, so-called global guidance litigation. This is an effort to clarify rights and responsibilities, usually by asking a domestic or an international court to opine, often to issue an advisory opinion. These cases also are increasing. So with all this talk about litigation, an obvious question arises, who's winning? Well, when we look at the outcomes in this litigation, we see overall that plaintiffs fare decently. They are racking up a win rate of about 55%. If you look at all the data, there's about 10% of cases winding up with a neutral outcome, which might be withdrawal or settlement, and that leaves defendants prevailing in about 35% of cases. So when you break down the results by year here, you can see some spike in losses in 2020 and 2021. Researchers suspect that one thing that's going on here in this increase in losses is that it's happening in tandem with what you saw earlier in the diversification of the theories of liability. So as plaintiffs are bringing more varied theories against more different defendants, they're experiencing losses. But that's kind of a learning process by which they are sort of hit and miss, try a new theory, it doesn't work, you refine the theory, you come back and try again. So it's suspected that those loss spikes are not going to hold over time. So we'll see again, as I said, the overall question, what will be the impact of litigation on our environmental picture? Will it be a significant mover of changes in social policy and economic policy? And will it ultimately, or could it have an impact on climate change? And a question that we should take up as a group as well, should it? Is litigation an appropriate vehicle to bring about change in this area? So thank you for your attention.